Welcome back to Law and Crime, everybody. I'm Jesse Weber, and I'm joined here on set by, do you recognize her? She's back. Jonna Spilbor, our Law and Crime legal analyst. We also have with us Judge Willcott, who's via Skype. We'll bring her on in a minute. We have a lot of cases to talk about. We're going to be live day in 2 different courtrooms, so let's break it all down. So how helpful is he, Jonna? You tell me. State witness, can't positively identify, describes some of the characteristics of the defendant, says they're wearing masks, no masks are recovered. Your thoughts?
Well, it's a bit of a problem for the prosecution because this is not a case where somebody, is shooting up at a party and you've got any witness that could say, aha, it was Jesse. I saw his face. I recognized him.
Don't get me involved in this. Don't get me involved in this, Jonna.
I mean, it's so common for people to commit crimes masking their appearance for that reason. So the prosecution has to put together some other circumstantial evidence in order to get a conviction here. It may not be that easy, Jesse.
Well, you tell me. I'm also back here with juvenile judge and trial attorney Judge Willcott. Circumstantial evidence. We're listening to the text messages today, trying to understand the whereabouts, what each character was up to, and now we're learning more about what the defendant was doing on the day of the murders. He was communicating with his co-defendant right at the time of the shooting. Your thoughts?
Well, I do think it's good circumstantial evidence, but I agree with Jonna. And what the prosecution's really going to have to do in this case, Jesse, and we've talked about it a little bit before, in their closing argument, I have seen cases made in the closing argument because that's the opportunity to connect all of these dots and show that there's so much circumstantial evidence that there is no doubt that this person committed this crime.
2 good points. I have great guests today. I'm so lucky. And to talk about a really complicated case. But you know what I want to go to next? Really important witness, Charles Rapagel. What happened when he was under cross-examination? That's the question. Let's go to that right now. All right. So, Jonna, we like a good cross-examination. And we see the defense cross-examining what you could argue is the prosecution's key star witness. What are they trying to get at here?
Exactly. Well, here's a couple of points. Criminals can be victims too. And in this case, what I think the defense is trying to get across here is, well, wait a minute. We have somebody who is actually a criminal, who's claiming to be a victim, has motive to maybe exaggerate, lie, not be 100% truthful here. And since credibility is always an issue whenever somebody is on the stand, the defense is very, I'm going to say subtly, trying to undermine or undercut this particular witness's credibility here.
And Judge, you tell me. We have a guy here who's hosting a party. His house is filled with drugs and weapons. We see text messages where he's involved in the illegal drug trade. He's speaking to Coleslaw and Teddy from Michigan, now 2 of my favorite names of all time that we've ever covered in a trial. What is the jury thinking of him? What is the jury thinking about this whole situation? I mean, what should they be thinking about in terms of how this shooting went down?
Well, listen, if I were the jury, I'd be thinking, wow, guns in every room, drugs in the house. There are a lot of people that could have had the motive to come in guns blazing and shooting up the place and shooting at people. So I think the reasonable doubt that the defense can really argue from this person's testimony is he was involved in really bad things, which mean there were probably really bad people involved in his life. And there are a number of unnamed people potentially that could have committed this crime.
Now, Jonna, let's mention that. So Luke Kasukis is this other character who the defense has said, this is the real person we should be looking at. He was investigated, was a person of interest, questioned, but never charged, never arrested. That's him right there. Now, the defense is saying this is the real person that could have done these shootings. So what do you think's going on here? Do you think a jury likes this alternative suspect? They like a conspiracy theory. They like to know, hey, wait, why was this guy looked at, but he wasn't officially charged here? What do you think?
Yeah, I don't know if the jury likes that so much as it really does lend itself to reasonable doubt. And that's really all the defense doesn't have to prove that it was some other party who actually did this. They just need to raise enough evidence to convince a jury that it might not have been their client. And so far, it's quite possible that they're being successful in that.
Maybe. I mean, I would love to know what the jury's thinking as of right now. But Judge, he also got shot. The defendant got shot. So it would have been one thing if this jury saw him wheeled out in the wheelchair like during the, I think it was during his arraignment, but he was shot in the lower back and the buttocks region. How does that figure into this as well?
Well, I think it's, again, something the defense can play on to raise reasonable doubt, because guess what he didn't do, given the location of the shots, like you just described, lower back and buttocks? He didn't do it himself. So who shot him? What was he doing? If he was the person that came in and shot these other individuals, then how did or why did he get shot?
And I'll tell you what the prosecution's saying, that his co-defendant, that his accomplice, accidentally shot him, Marcus Stewart. But does that make sense? We'll talk about it right after this. Okay, just to make this clear, that was the prosecution responding to the defense's motion to dismiss. And Jonna, what we're learning here is they're saying, look, his DNA is on all these key pieces of evidence. And even if he wasn't the shooter, he was there, he was a part of it, he's responsible, this is first-degree murder. Is that accurate?
Well, is it accurate? That's the intent
of the
prosecutor. Well, yeah, you can have like a co-conspiracy sort of theory where two people who are acting in concert for a crime can be found equally guilty, and you don't have to prove whose bullet actually gave the fatal blow. That is accurate. For purposes of this motion, what the defense is trying to show is that there is at least one element, one piece of any of the crimes that the prosecution has completely failed to present any evidence on, which would lend itself to granting that motion. Jesse, these motions are never granted. I mean, it's very, very rare. But every time you're on trial, a defense attorney has to make the motion, at least to preserve the record on appeal. That's what happened.
Yeah, no, obviously that was their job to do. But Judge Ashley, let me ask you this. Let's say he goes that night with Marcus Stewart and maybe even Luke Kasukis, goes that night just to have a conversation with Verpagel and Sean Henry. All of a sudden, they take out their weapons and they start opening fire, and he's like, oh, whoa, 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 and he runs away and he gets shot. Is he still responsible? Should he still be found guilty of first-degree murder? And how do we know that didn't happen?
Well, at this point, we don't know that didn't happen. We have to hear the rest of the evidence and rest of defense evidence. But having said that, Jesse, the problem is the intent. And when you go somewhere like that, the prosecution's going to argue clearly you had the intent to engage in the activity to shoot because of the weapons that you had and the people that were there. And you can't just say you were going to have a conversation. But I think that, we were just going to have a conversation weighs into the defense's argument.
Well, it is what the defense is arguing. But as you can see, from this explanation from the prosecution, DNA is a huge factor in this case. Let's go back to when the forensic scientist in this case talked more about DNA. Okay, so what do you think about this? The idea that his DNA is on the assault rifle, the gloves, the hoodie, in the car. There's bullets in his pocket. Those bullets match the same ones that are found in this BMW, and they're also match the revolver that was found as one of the murder weapons along with this rifle that was also found next to or by the getaway car. I mean, he's tied to this in a lot of ways.
Well, this is a quintessential circumstantial case, right? It's not every day, Jesse, that crimes are committed and you've got an eyewitness who clearly knows who did it and everything matches up and boom. If we did, then you wouldn't be having a trial. This is a case where you're not exactly sure the identity of the perpetrator or perpetrators, so you have to piece together circumstantially the bullets, the location, the pings, all this, and the jury is allowed to make inferences from that evidence, and that's exactly what the prosecution is doing here.
Judge Ashley, let me ask you this. If they ultimately convict him, as Jonna said, it's not entirely clear one way or another what happened. If they ultimately convict him and it's after long deliberation, and maybe it turns out to be a very narrow vote, does that mean it's more or less likely that that same jury would vote in favor of the death penalty?
Well, I do think that weighs in, and I think that a jury, if they convict based on circumstantial evidence, again, just like Jonna said, we don't have an eyewitness, we don't have anyone, we don't have a video that says he did it. I think that that's a factor against the death penalty in terms of the jury deliberating on the death penalty or not.
Yeah, it's something to think about. We're not quite there yet. We'll have to see what ultimately happens with the closing arguments, and then it'll be in the jury's hand. We're going to take a break, and when we come back, a lot more to discuss. Be right back.